Hey, everybody, welcome back to the Shanty. I know what you're saying. We were supposed to do a Shanty last week, but we didn't. And that's my fault because it was a holiday week and I honestly didn't feel like working. And so I took Monday off, and we usually record these on Monday. And I'm being lazy again. And you can see that by the fact that I have a guest here today. And I love to have guests because that means that I have to do less work and the guests have to do more work. I have with me today Brian Masternak. Brian is a partner and a litigator in our litigation practice group. And Brian specializes, although he does all kinds of civil litigation, he specializes in a couple of areas. One I think is going to be of importance and interest to you all today, and that is the area of antitrust litigation. Brian is the go-to guy on antitrust issues, and apart from being super smart and highly educated, he's also one of the funniest guys I know. So say hi, Brian.
Hi.
So what we're going to talk about today is, as you all know, we've got a lot of issues going on now with actually getting employees to come to work for us. We're having a real hard time finding employees. We got into this employee shortage. It was, we came out of the pandemic and all of a sudden nobody wanted to work anymore, I guess. And we got into a real employee shortage, and we're running the gamut from not being able to find unskilled employees to not being able to find highly skilled and very important employees. So I brought Brian on because I had a couple of questions about that. Now, you guys all know that we've talked in the past about non-compete agreements, but it got me thinking about what else could we do. So, for example, let's say I'm an employer and I spend a lot of time and effort, Brian, I'm recruiting people, I'm spending money and a lot of my time to recruit them, and I just happen to be a member of, some trade association, the Organization of Unicycle Manufacturers, let's say, and we have trade meetings. And I've decided that, I think it'd be a really good idea when I go to these trade meetings, if I could just maybe get a little side agreement going with some of my unicycle HR colleagues to say, hey, let's strike a little deal here. How about I agree not to steal any of your employees and you agree not to steal any of my employees? Anything wrong with that? Any reason I can't do that?
Steve, there's really nothing wrong with that as long as you're open to the idea of going to prison. So, no, seriously, those sorts of arrangements, under the antitrust laws we would call no poach agreements, have always been a violation of the Sherman antitrust law and also of the various state antitrust laws that are also enforced and that really track the federal law. The difference is, historically, agreements among competitors to limit either hiring one another's employees or to try to agree on the level of wages that they'll pay to certain types of employees or controlling the types of benefits that they might offer to employees. Those have been looked at as really civil type violations that might merit a fine, but really weren't going to be treated like the true hardcore per se antitrust violations like price fixing or bid rigging that historically have ended up getting people prosecuted criminally. Back in 2016, the Department of Justice announced that they were going to shift their focus here, and for at least what they called naked no poach agreements or naked wage fixing agreements, they would actually start prosecuting those criminally. And when they say naked, it's not as exciting as it may sound. Really, all that means is these are agreements that aren't part of any other sort of potentially legitimate business operation, like potentially a joint venture or some other kind of resource sharing arrangement that might legitimately exist, but just simply one competitor saying to another, you know what, it would be a lot more convenient if you stayed away from my employees and I agree to stay away from yours. So back in 2016, they said, we're going to actually start prosecuting these things criminally. And then for a number of years, it was nothing more than a threat. But what we've seen this year, starting in late December of last year, the very first Department of Justice criminal prosecution for a wage fixing agreement where a group of competitors got together, a group of competitors who operated physical therapy outfits in Northern California got together and said, we're going to fix a wage below which we won't pay our competing physical therapists. That was the subject of a criminal prosecution beginning December last year. And then in January of this year, the very first no poach agreement, which was among a group of hospitals in the Dallas area, where they agreed not to hire one another's high-ranking corporate executives, has been prosecuted. So those are starting to wind their way through the system now. And so, you know, the temptation has always been there for employers to want to enter into these agreements, because it really is true. You do invest a lot of time and resources and energy in finding the best people and training them, and you'd love to keep them around. And of course, you know, non-competes and non-solicit agreements in their own employment contracts are one way to potentially accomplish that. And I'll let someone who's smarter than me talk about those another time. But when you want to go to the next level and say, in addition to whatever agreements we're going to strike with our employees, we also want to have some agreements among competitors not to hire each other's folks, you just can't do that unless you're really ready to face some criminal consequences.
Well, and Brian, that's interesting because you talk about physical therapists and hospitals, and usually when we think of antitrust, we think about, you know, the big oil companies, the big car companies, big stuff like that. But it sounds like it goes deeper than that, and it could go into even smaller groups of employers that are colluding, if you will, to do this stuff.
Absolutely right. And that is one of the problems with antitrust enforcement is people sometimes think, you know, this is just for the Microsofts of the world. This is just for the Apples of the world. But it really isn't. When you look at some of the big antitrust enforcement efforts that have come down over the last several years, you know, waste management, recycling industries, those are ones that have been hit hard. And those are companies where, you know, you're not really talking about big national household names. You're talking about smaller businesses, but no matter how big you are, if you're entering into these kind of illegal agreements, the government can come knocking at your door.
Okay, so what if I'm the Acme unicycle company, but I'm not talking to other unicycle manufacturers? What if the guy next door to me happens to be the head of HR for Mike's Microwaves, and he and I agree we share some marketing employees, for example, and we agree that we're not going to poach each other's marketing employees? Is that a problem, or because we're not in the same industry, am I okay?
It still is a problem. And the reason why is, you know, when the antitrust regulators are going to look at these things, they look at markets, okay? And a lot of times if you're talking about, say, price fixing, the relevant market that they're looking at is the product that's being sold, okay? So your competitors for a price fixing case would be the other companies that sell unicycles if you sell unicycles, or microwaves if you sell microwaves. But in the context we're talking about, the relevant market really is the labor market, okay? So if you sell unicorns, maybe you sell unicorns, maybe you sell unicycles, maybe you sell unicorns unicycles so they can ride those around down to the microwave store and buy one of those. But regardless of what industry you're in, if you are, say, all hiring IT professionals, you're all hiring administrative staff, whatever the job function is, you may be competing for that category of worker, even if the products you make don't have anything to do with each other. And so the same principles that would apply to actual product competitors apply in those labor market competitor situations as well.
Okay, so that sounds like to me, you know, our audience is HR people and stuff like that. And it sounds to me like if I've got 20 companies in an industrial park and all the HR people in the industrial park get together and say, we won't poach each other's employees, we could have a problem, even though it might be 20 different industries or 20 different companies.
Exactly right.
Okay. Is that it? That's the rule? No exceptions? I can never have this kind of agreement?
Yeah, it's not quite as cut and dried as that. Again, you know, when I started out talking, which probably seems like a long time ago to all of you listening here, you know, I referenced the naked restraints and the naked agreements. those are the ones that really put you most at risk of criminal prosecution. If you've got a situation where, for example, maybe you started a joint venture with a competitor and you're working on something productive and you're going to bring your respective employees to work on that joint project, but you say, you know what, if I'm going to bring my employees and your employees and you're going to get to know each other, I want to put some protections in place to make sure that you're not going to hire all my folks after I introduce you to them. Under those circumstances, they're probably going to look at it and evaluate it under what's called the rule of reason, which basically means as long as you can come up with a legitimate pro-competitive rationale for what you've done, it's going to be okay. So, this is a little more complicated than just saying you can never enter into those kind of arrangements. But what I would say is if you've got some kind of business relationship going on with a competitor, whether it's a product competitor or just a competitor in other labor markets, and you think that, because of the relationship you've got or some kind of collective opportunity that you're exploring with this other co-venturer, you might be able to engage in these kinds of workplace limitations. You really need to talk to an antitrust lawyer about it.
Okay. So I need to call you before I enter into some kind of agreement like this, even if I think it's legitimate. Make sure that everything's all right. All right, one more question.
Sorry, just because the consequences are so severe.
Right. I mean, you could go to jail, as you said at the beginning, potentially.
Yeah.
All right, one more question, and then we'll get you out of here. Is there anything else I need to worry about on the horizon with respect to non-compete? We see the DOJ now enforcing these things. You mentioned 2 different cases. What else do we need to be on the lookout for?
Well, I think the thing to be on the lookout for is, as we see with the new criminal investigations or criminal prosecutions that actually are occurring now under this new administration, there's been a real revitalized interest in enforcing the antitrust laws. And in fact, just last Friday, President Biden issued a very wide-ranging, sweeping executive order that touched on a whole bunch of different industries and a whole bunch of different changes that he would like to see appropriate agencies undertake. Among those was an executive order directing the Federal Trade Commission and Department of Justice to go back and reevaluate the guidance that they gave back in 2016 to human resource professionals to guide them through the antitrust laws and what they needed to consider. So there was a 2016 publication, HR guidance, antitrust guidance for HR professionals. And in this executive order, the president expressly directs the FTC and DOJ to revisit those guidelines and see if there are things that need to be changed. And they're not going to change them to loosen them up. One of the things that is called for in those HR guidelines is something that I know a lot of our clients deal with from time to time, which is, okay, maybe we know that we can't enter into formal agreements about what we're going to pay our respective employees, but we sure would like to get at least some benchmarking information. We'd like to be able to share some data to know what other folks are paying or what kind of benefits they're providing to people. And under the 2016 guidance, there's been some pretty clear rules of thumb that you can follow to know what you can do and what you can't do in terms of sharing, wage and benefit information. And, they had a checklist of it needs to be historical information, not current or forward-looking information. You need to have the information aggregated by a third party. You need to have at least 5 participants that are supplying information, so we can't tell exactly who is who. So there's been some pretty clear guidelines on how exactly you can go about sharing information if you want to. But in this executive order, it appears that the president is saying, we want to take a harder look at that and maybe even tighten up the regulations about how and what kind of information you can share about wage and benefits. So that's something we're going to have to keep an eye on. In the meantime, I think the old guidance still applies, but in this current environment we're in, where we know that there's going to be a really aggressive antitrust enforcement, this is something that everyone's going to want to, I think, be mindful of going forward to make sure that nobody ends up in hot water. Okay,
thank you very much. That was very helpful. If you have any questions, anybody out there, if you've got any questions for us, Brian, you can find Brian on the on our website or call your WN&J lawyer and give me a call. We'll be happy to walk through these issues with you. Brian, I can't thank you enough for joining me today, and all of you, we'll see you in 2 weeks.
All right. Thanks, Steve.